Ready? 3, 2, 1, start. On 17/9/2002, the learned Metropolitan Magistrate passed a summoning order. Stop. The application by the respondent recalling the summoning order was dismissed by the learned Metropolitan Magistrate, an order dated 9/2/2004. Stop. One of the contentions raised by the respondent in support of prayer for recalling the summoning order was that the checks in question were entrusted to the complainant as a part of the business transactions between the parties and were not meant to be encashed. Stop. It was stated that the checks had been tampered with, filed by the complainant or his associates to make alteration in the amount and the dates without the consent of the drawer, that is respondent. Stop. While rejecting this contention, the learned Metropolitan Magistrate in the said order dated 9/2/2004 observed as under para. The accused has filed application for recalling of the summoning order on the grounds that the said checks were not issued on account of any liability and the said checks were given to the complainant as security for business purposes. Stop. The accused has also alleged that the accused misused the said checks after tampering the same. Stop. It is important to note that the accused has admitted that the checks have been signed by him and were issued in favor of the complainant. Stop. The allegations of the accused applicant that the checks were not issued in discharge of liability requires evidence which the parties have yet to lead. Stop. Further, the other allegation as mentioned in the application that the complainant has misused the said checks after tampering the same can also be not decided without evidence which the parties have yet to lead. Stop para. By a subsequent order dated 24/2004, the learned Metropolitan Magistrate framed charges under section 251 CRPC. Stop. The complainant's evidence was then closed on 22/12/2004. Stop. Meanwhile, criminal revision petition number 440 of 2004 filed by the respondent challenging the order dated 9/2/2004 passed by the learned Metropolitan Magistrate was dismissed as withdrawn by the learned Additional Sessions Judge. Stop. On 15/7/2005, the respondent examined himself as DW1 and was also cross-examined in part. Stop. The cross-examination was concluded on 17/8/2005. Stop. DW2 was examined on 7/12/2005 and thereafter the defense evidence was closed. Stop. The case was listed for final arguments for 13/2/2006 and after the arguments of the complainant were heard on that date, the case was adjourned to 15/2/2006. Stop. Again, an adjournment was granted for 15/2/2006. Stop. Thereafter, on 8/3/2006, by a detailed order, the trial court disposed of an application dated 31/8/2005 filed by the respondent for sending the checks in question for the opinion of a handwriting expert. Stop para. The criminal revision petition number 44 of 2006 filed by the respondent challenging the said order was dismissed as withdrawn before the learned ASJ on 18/3/2006. Stop. The said order has become final. Stop. The respondent also filed an application under section 311 CRPC for recalling the complainant. Stop. By a detailed order dated 8/3/2006, the learned Metropolitan Magistrate dismissed this application. Stop. Over.